speaking today about the Charter of Rights and Pierre Trudeau with a man who knew the former Prime Minister pretty well, his former senior policy advisor and principal secretary, Tom Axworthy.
Of the Charter of Rights, when Prime Minister Pierre Trudeau decided he wanted to finally bring this into fruition, could you let us be a fly on the wall of those discussions? What was inspiring his decision and this action to make this?
In Canada, we were generally a tolerant nation, but we'd had enough abuses to show that sometimes in the middle of war, political parties go off the deep end, the general civility of Canada and the devotion to human rights has sometimes been cashiered in. We can look at the rights of French Canadians to their language. Well, the Manitoba schools question in 1890 took them away. And a minority was abused by a majority. Japanese Canadians rooted out from their homes because of the xenophobia that occurred during World War II. But what could they do? They were dependent on the goodwill of Parliament, the goodwill of the Prime Ministers of the day. That wasn't enough. In Quebec, Premier Duplessis used his power to take away the rights of religious minorities he didn't like the Jehovah's Witness. So I don't want to paint the Canadian history as only a history of abuse. There are also many achievements there. But there were certainly enough that the need to better protect the right of Canadians was thought to be, by Mr. Trudeau and many others, an important priority. In Canada, there are many people who have contributed to the concept. One of them was a contemporary of Mr. Trudeau's, Frank Scott, a very well-known professor, jurist, poet actually, in Quebec, who began writing about a charter in the 1950s. He leaned toward the CCF and the NDP, so that this view of rights was not any one party. It was shared by Canadians from all parties. Next, I would say the next important actor was John Diefenbaker, a conservative. So Mr. Diefenbaker brought in a bill, the Charter of Rights, in our Parliament, but not in our Constitution, which meant that it could be overturned by other parliaments. That issue of who was supreme to judge the judiciary or Parliament wasn't settled. So along this time, that Mr. Trudeau, as a young man who was an activist in Quebec in the late 40s and the 1950s, saw the abuses of his government at the time, Mr. Duplessis, fought them in a magazine called City Libre, became a professor of law at the University of Montreal, and beginning in the 50s, Mr. Trudeau, as an academic, began to write on the need for a charter. So this idea of his was not something that he came to as Prime Minister. This was the reason why he came into politics, to try to get this important change achieved.
So played that big a role in his life.
I think it did in a very major way. That he became convinced that to complete the system of liberty in Canada, we needed to have a charter that was protected and adjudicated by the judiciary, because he personally lived in Quebec, led by a man who often usurped his power. And so every day, Mr. Trudeau would be seeing in Quebec examples of power untrammeled. So this became a very major part of his intellectual makeup. And then when he made the decision to no longer be a professor, but to become a politician, one of the first things he did when Mr. Pearson, he won the election in 1965, he became parliamentary secretary to Mr. Pearson. Mr. Pearson moved him up in the cabinet, making him Minister of Justice in 1967. And one of the first things that Mr. Trudeau did was to bring out an announcement that he and his government was going to work toward a Charter of Rights. Nobody would have been surprised. Anybody who had read Pierre Trudeau's writings from the 1950s in City League would have known that the first thing he would move on would be a charter. This is a very interesting example beyond the importance of the charter. I speak about it with my students all the time. That in Canada, or perhaps in most democracies, people think, well, what can I do to change? How can I change the system? The system's so big. I've got this idea, whether it be on employment insurance or the environment. I mean, what can we really do? Well, I often tell them, you know, when Pierre Trudeau and his friends began to talk about their charters, there were 3 or 4 of them in a basement. And they wrote articles about a magazine. And then they decided eventually to run for Parliament. And then when they ran for Parliament, they became ministers. And when an opening occurred, he became Prime Minister. But he came in with an agenda. He had an idea. This was not done for him on a briefing note by somebody. This is why politics can be very demanding, and one loses your privacy and a variety of other things. So you have to have, I think, good politicians have an animating idea that keeps them going in a very difficult life. There's no question that keeping Quebec in Confederation and expanding personal liberty in Canada through amendments to the Constitution, that was the animating focus of Pierre Trudeau's life.
And yet there were challenges when he brought up the idea, right? There were quite a few challenges. And I read somewhere that you said it was debate revealed between people who didn't agree with it and those that did. 2 compelling visions of Canada. One was a dream of nation building with individualism at its core, and one was province building with Parliament being supreme. Mm-hmm. So was that really the main struggle between 2 camps? Is that how you would sort of define it?
I think so, because the idea of a charter, of enshrining our rights, writing them, putting them in the Constitution, almost instantly was popular with Canadians. Now, it wouldn't be the #1 issue that they would say. It was always the economy or healthcare or other things. But when the idea was put before Canadians, they'd say, yes, that was a very good idea. But there were opponents to it, very significant ones, and in particularly among the provinces, the provincial premiers, because Mr. Trudeau and his government, as Prime Minister, was willing to give to the courts and the Supreme Court the ultimate authority over rights, i.e. take it away from himself as Prime Minister. To say, no longer will I be the arbiter of this, it will in fact be in an independent judiciary. It was a diminution of prime ministerial power or governmental power. Because Canadians could use the Charter to claim their rights, not to petition. To say, please, can I have my rights? No, you got to have Clayton Ruby or a lawyer go in front and say, her rights have been impinged, we demand justice. It's very different, but we demand justice to, please, give me justice. So that was a diminution of political power in favor of a judicial interpretation and adjudication. But there were many politicians who were uneasy with giving that amount of interpretive power and adjudication abolition power to the unelected judiciary. So there was a real debate around, held by honorable men and women on both sides of that debate. Where would our rights be most secured? Mr. Trudeau and those who supported him felt that ultimately the judiciary was a better ultimate defender, because we had so many examples of politicians for votes or whatever it is giving in to the temptations to abuse their power. And that, in my case, empirically or as a historian, there was no question where I felt the rights could be better protected. But there was a second line of a particular opposition as well in Canada. That debate that I just said would be held, it's still going on in the United Kingdom today, for example, about whether Parliament will be supreme or whether it will be the European Court of Justice. So that was a debate that politicians and jurists and others have had for many years, many generations. But there was a particular also debate that was peculiarly Canadian, and that's around language rights. Mm-hmm. Now, as I said, Mr. Trudeau, one of his animating forces was to have justice for all Canadians, but in particular for our French-speaking Canadians, or minorities in general, English speakers in Quebec, and French speakers elsewhere, because our history of minority rights protection around language was also not very good. So one of his positive approaches to persuading his fellow Quebecers that Canada was the place that should continue to be their home was that, yes, we've had these abuses in the past, but we are going to protect language rights, the ability to be taught in French, to live in French, to have represented in the federal government. We are going to protect those rights in the Constitution, and we're going to protect the rights of English-speaking Quebecers in the Constitution in Quebec. Wherever there's a politician who is thinking of using majority power to take away minority language rights, the Charter will be one of those things, will be an immense hurdle that that politician will have to jump over, and the Charter may ultimately stop him or her from doing that. So, but the idea then of making language into a right, that was an expansion of the concept of rights. We know that liberty is a right, and equality of treatment is a right. Those are traditional political rights that we've had since the French Revolution, or the British Bill of Rights in 1689. But the addition in Canada to have language rights added to those rights, which Mr. Trudeau felt was essential, because this is a country with 2 official languages, and a good number of our fellow citizens were trying to leave it, that was a very important new addition to the architecture of rights to be added in the Canadian example. Now, in Canada, that also provoked much opposition. It provoked opposition from Quebec nationalists who didn't like the idea that English-speaking Quebecers' rights would be protected, because they were quite happy to potentially abuse English-speaking rights the way that French-speaking rights had been abused in Manitoba. So they were unhappy that it would be out of the political hands and put into the judicial hands. And similarly, many others in the rest of Canada were also had their doubts about the extension of the French language guarantees to the whole country through that provision. So, as well as the general debate over rights and who best to protect them and adjudicate them, we had a particular debate in Canada over the expansion of minority language rights. That was very much a Trudeau or a Canadian addition to the rights universe. And it's one that many countries now around the world look at our Canadian Charter, because they also have language issues. In Ukraine, there's a debate between Ukrainian speakers or Russian-speaking Ukrainians. Well, lots of people are interested in our language protections now, because a lot of new ground was broken in our Charter. The things that were being changed were both the Charter, but we're also an amendment formula, how to amend our Constitution in the future. And Mr. Trudeau had included that there would be agreement on the provinces, but if there was not, we would have a referendum mechanism. That is, you would go back to the people to have a referendum on these kinds of changes. Now again, those premiers who are worried or upset about the idea of a charter and the judiciary having this new sense of powers were even more worried that the people in a referendum would have the power to decide on a constitution rather than themselves. It was another one of our efforts to take powers away from politicians and give it to individuals. In one case, the vote, in the other, the charter. So there was tremendous opposition among the premiers who we met that one last time, and ultimately, after some very intense bargaining, a deal was struck. And what was the deal? The deal essentially was, all right, we will accept your Charter of Rights with a notwithstanding clause, but you accept our amendment formula, not the one that you proposed with a referendum. It was, when you got down to it, it was an old-fashioned political trade. We took the Alberta amending formula, and Mr. Lougheed and his colleagues took the Charter of Rights that Parliament had approved. It was a deal.
No one really came to their exact ideal place in the end. So notwithstanding clause was a big part of that, of the compromise on this end. And you've talked about the notwithstanding clause. You've mentioned, is it the sort of Damocles or a paper tiger in an article that you wrote?
Sort of Damocles.
Damocles, right. So is that, how would you define that compromise, this notwithstanding clause, and what did Pierre Trudeau think about it? What do you think about it?
Well, the suggestion was that premiers would accept a charter, but they would have a right to also bring to their legislatures in areas around provincial responsibilities that, notwithstanding what the charter says, we are going to go against that provision by this piece of legislation. But it would, that wasn't a, that wouldn't stand forever, that if they brought that in, they would have to renew it. So it was a compromise. Mr. Trudeau did not like the idea of a notwithstanding clause because it went against the original idea I talked about, which is that human rights were inherent and had to be protected at all costs as adjudicated by a judiciary. What we came out with was that in practice that's what largely has occurred, but in theory provinces or premiers can still use the notwithstanding clause to say whatever it says in the charter, we will use our power to do this. But they will have to renew it. So it will be difficult to do. Now, soon after we brought in the charter, for example, Mr. Bourassa, there were tremendous debates over language rights within Quebec, used the notwithstanding clause in a way that many English-speaking Canadians felt impinged their rights. But he paid a real political price. There was a tremendous debate over it. So what has happened now de facto is in our Constitution, a province or Parliament can still, if they really think this is so important, they still have now the legal right that they can say, for a limited time, your charter right will not apply. But the use of it has been very rare, because if you take away somebody's charter rights, it suddenly elevates what might have been a minor issue into a front page issue, i.e. it's not done lightly. And it hasn't happened very often in Canada since. So at the time we didn't know how it would evolve. Theoretically, it doesn't jibe with Mr. Trudeau's vision, and Paul Martin, as Prime Minister, said that he would seek another amendment to take away that compromise that Trudeau had agreed to. But I think Mr. Trudeau, when he got down to it, was very sorry that he had to make that compromise. But he also knew without that compromise, there wouldn't have been the compromise over the charter. And in his heart of hearts, I think he was happy that he ultimately didn't have to go to Britain over the heads of the premiers, that it was better that we did have a consensus with the deal that we signed, even if it included a notwithstanding clause.
What do you think he'd feel today? What would he feel today? Where would he stand on the charter and its use? And
Oh, I think he'd be enormously pleased and gratified by what has occurred. The charter has become an absolute essential instrument of every lawyer's toolkit. They look to see whether there are implications for the charter on the cases that are before them. Our courts have been very active and expansive in looking at what these measures meant in 1981, in the constitutional package that we brought out in 81 and 82. Just to take one example, the provisions on the rights of Aboriginal peoples to have their rights respected on consultation and the duty to consult and so on. Those provisions, Section 35 and so on in the Charter. But our courts have taken those written provisions, Section 35, and interpreted them broadly and have given our Aboriginal peoples a lot of scope on resource developments. That is, it's not just a dry piece of paper. It's being used on issue after issue. Now, there are some who still oppose the Charter and still oppose the rights of the courts to be as interpretive and the ultimate authority on it. But I, for one, who was part of the Charter, I've been gratified, delighted on the evolution of the judicial role in Canada. And where are you with us today, Mr. Trudeau?